We now arrive at the final portion of the residential listing contract, exclusive right to sell, rent. This is where enforcement, dispute resolution, legal mechanics, and execution formalities come together. Everything you have learned about compensation, authority, disclosure, and obligations is supported and protected by this section. If the earlier sections define the relationship, this section defines what happens when things go wrong and how the contract legally survives scrutiny. Remedies, alternative dispute, resolution, and arbitration. The agreement requires mediation first for any dispute arising out of or relating to the listing contract. Mediation costs are shared equally. If mediation does not resolve the issue, the dispute moves to binding arbitration unless one party opts out within 30 days after mediation concludes. If the parties cannot agree on an arbitrator, the matter is submitted to the American Arbitration Association under its real estate industry rules. The arbitrator's decision is final and non-appealable, and judgment may be entered in a court of competent jurisdiction. This is significant for Arizona brokers because arbitration can be faster and less expensive than court litigation. However, it also limits appeal rights. That is why owner initials are required. The seller must knowingly agree to waive certain litigation rights. Phoenix Metro. Example: a Scottsdale seller refuses to pay commission after closing, claiming the buyer was already known. The listing broker invokes mediation. If unresolved, arbitration determines whether the broker produced a ready, willing, and able buyer under the contract. The agreement also prohibits class or collective actions. Disputes must be brought individually. This protects brokerages from large-scale consolidated claims. Discussion. Question: why does the contract require mediation before arbitration? Answer: mediation encourages negotiated resolution, reduces legal expense, and preserves professional relationships before escalating to binding proceedings. Attorney fees and costs. The prevailing party in any dispute arising out of the agreement is awarded reasonable attorney fees and costs. Costs may include expert witness fees, investigators, and arbitration expenses. This clause shifts risk. If a seller breaches the agreement and loses, they may owe not only commission, but also legal fees. As the listing agent, you should explain this clearly at signing. Transparency prevents future conflict. Gilbert example: a seller withdraws the property mid-contract without broker consent and refuses to pay earned compensation. If litigation or arbitration confirms breach, attorney fees may be awarded to the brokerage. Discussion question: why is a prevailing party attorney fee clause important? Answer: it discourages frivolous disputes and ensures the non-breaching party is not financially harmed by enforcing contractual rights. Additional terms and conditions, customization and risk control. This blank section allows custom negotiated terms. In metropolitan Phoenix practice, this is often used for early cancellation conditions, reduced commission upon specific events, special marketing instructions, builder exclusions, reserved mineral or water rights. As a contract writer, this is where clarity matters most. Ambiguous additional terms create litigation risk. Always draft specific, measurable language. Example: instead of writing, owner may cancel any time, write, owner may cancel after 60 days upon 10 days written notice if no purchase contract has been executed. Discussion. Question: why must additional terms be written clearly rather than generally? Answer: because ambiguity is construed against the drafter and can invalidate or weaken enforceability. Assignment, Arizona law, and jurisdiction. Neither party may assign rights or obligations without written consent. This prevents the seller from transferring obligations to another party without broker approval and prevents broker transfer without consent. The agreement is governed by Arizona law, and jurisdiction is exclusively conferred on the state of Arizona. This ensures disputes are resolved under Arizona statutes and case law, not another state's law. In the Phoenix metro area, This is particularly important with out-of-state investors selling Arizona property. Notice requirements and delivery methods. Notice must be in writing and is deemed delivered by hand delivery, facsimile, email, overnight courier, or U.S. mail. The contract clarifies when delivery is deemed received. This section protects against arguments like, "I never got that cancellation notice." As a best practice, always send important notices by email and request confirmation. Maintain records in compliance with ARS. Paragraph 32.2151.01 Record Retention Requirements. Discussion. Question. Why does the contract define when notice is deemed received? Answer. To eliminate disputes about timing, especially where deadlines trigger legal rights or termination. Days, electronic signatures, and entire agreement clause. All references to days are calendar days unless otherwise specified. This matters for cancellation windows and protection periods. The contract allows electronic signatures and counterparts. This aligns with Arizona's adoption of electronic transaction laws and modern brokerage practice. The entire agreement clause confirms that the written contract and its addenda supersede all prior oral or written agreements. If a seller later claims, "You promised something verbally," this clause protects the brokerage unless that promise was written into the agreement. Failure to initial a page does not invalidate the agreement. This prevents technical arguments attempting to void enforceability. Phoenix example. A seller claims a verbal commission reduction was promised. The written agreement controls under the entire agreement clause, acceptance, execution, and signatures. The owner section formalizes signature, printed name, address, phone, and email. This ensures proper identification of parties with capacity under ARS contract law principles. The listing broker section confirms Realtor R membership and adherence to the Code of Ethics. This reinforces professional standards beyond statutory minimums. Signatures represent legal acceptance. Once executed, the exclusive right to sell becomes binding and enforceable. Discussion. Question. Why must both printed names and signatures appear? Answer. To clearly identify the contracting parties and avoid disputes about who executed the agreement. Bringing the listing agreement together. We have now completed the residential listing contract, exclusive right to sell or rent. You understand? Parties and property identification, pricing and term, compensation structure, agency and limited representation, broker authority, owner obligations and disclosures, remedies and enforcement, execution mechanics. Every blank you fill carries legal weight. In the Phoenix metro market, contract writing is not clerical work. It is risk management, negotiation strategy, and legal compliance combined. When written properly, this listing agreement protects your brokerage, clarifies expectations, reduces conflict, and creates enforceable rights.